Hey guys, my name is Andre and I'm an investigative journalist with ASD Docs. Today's video is brought to you by my defense guide, aka Luis Sanchez. On August 5th, 2021, Luis Sanchez and I collaborated on a video titled Watch Defense Attorneys Conspire Against Their Own Client. Judge Retires After Video is Released. Now, I'm not even exaggerating when I say that the response from you guys has been unbelievable. Many of you have voiced your concerns by making phone calls and emailing the appropriate parties, and some of you have even donated to Luis Sanchez's GoFundMe. But understandably, we've also gotten some people still questioning the validity of our investigation. Luis Sanchez wanted to address 5 of the most common questions that he's been receiving since this video was released. If you haven't already, subscribe to my defense guide to stay up to date with this case. With all of that said, let's get started.
Let's go and get a warrant.
There was some questions from the previous video. Let's address them. Why are there no timestamps on the video?
The video provided by the court has no timestamp. It's just one video of a wide-angle shot of the inside of the courtroom, and that's it.
Do you have proof of the time the hearing was scheduled and the time that it was called?
This document is part of the court record. It gives the dates of the hearing, and it also shows where in the tape count the recordings pertaining to my hearing can be found. The first time my case was called was at 8:45. The second time, 10:48. On the following court hearing, I requested to be released, but the judge refused. She wanted to keep me in jail until trial.
You went inside after 9 a.m. People commented, well, he is late, so what is your response?
My case and over 40 other cases were scheduled to be heard at 9 a.m. that morning with Judge Bernards-Goodman. Also, before an attorney calls a case, they have to speak with their client first. They have to know how they're going to proceed with the case before they speak with a judge. Even arriving at 9:15 is not considered late in those type of mass scheduled hearings inside of that court. That is why the judge ignored the fact that I told her that I was there at 9:08 and that I had spoken with Heather Chestnut at 9:17. They didn't want to acknowledge that on the record, so they kept pushing 11:15 as the time I supposedly arrived.
Has it been reported to the Utah State Bar?
I reported the case to the Utah State Bar in 2018. In May of 2018, they replied, stating they had no jurisdiction, that I had to bring my complaint to the same court that had conspired against me. They practically ignored the accusations of misconduct and distorted my complaint so they wouldn't have to take action against any of the people involved.
How is the lawsuit going?
Out of 4 causes of action that I've raised in the lawsuits, 1 has been dismissed. The other 3 are still standing.
A plaintiff in a case like this needs to come forward with evidence showing the basis for a claim of a conspiracy. And as in the Abercrombie case, I conclude that there was no genuine issue of material facts concerning the existence of conspiracy. Because of the lack of evidence of a conspiracy between these two public defenders on the one hand and the prosecutor or the judge on the other hand, I conclude that there is not a basis for allowing a Section 1983 claim based upon a conspiracy. Therefore, I conclude that the Section 1983 claim should be dismissed with prejudice.
Why was a warrant called for my arrest?
Because you weren't here when we called the case.
I wasn't supposed to be here at 8:45.
It was after that. Come on, let's go see the judge.
I have proof here.
Okay, fine. You can tell the judge.
Like I said in part 1, this is just the tip of the iceberg. Stay tuned for part 2. Luis Sanchez and I go into far more detail into this massive case of court corruption. This has been an ASD Docs collaboration with My Defense Guide. Thanks for watching.